Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. We discuss domain name legal news. We review recent UDRP decisions. Every once in a while, we have special guests. There's 3 hosts to the show. I'm one of them. My name is Todd Ryan. I have 2 other co-hosts, Jeff Neuman and David Michaels. I'd like to say hi to them before we get rolling. Hey, Jeffrey, how's everything going today?
Hello, it's busy, really busy. Can't yet quite talk about what I'm working on, but you'll find out shortly.
Good to hear. Good to hear. Love it when the lawyers are keeping busy. And I talk about a lawyer call I had this morning. A couple panelists from NamesCon, not your panel, Jeff, but another one. Well, hey, David, how's everything going in the Toronto area today?
A lot cooler than it was this past weekend. A lot more comfortable.
Yeah, for those wondering too, we do stream live on YouTube, so you can listen here live on X. You can also listen live on YouTube. And then we have replays available here on X, YouTube, Spotify, and Apple now. So if you're on Spotify or Apple, search for Domain Name Law, also the DNX show. But search for Domain Name Law just to see how easy it is to find and, start listening to a recording so it shows that someone's listening to it, even if you've already heard it here, just to see how things are going there. So that's Spotify and Apple now. We're all over the place. Yeah, so before we get rolling, if you want to check out what we're going to cover today, we have an outline. It's at DNL, as in Domain Name Law, dnlshow.com/outline. You can see what we're going to cover today. Some legal news, and then, like I said, some recent UDRP decisions. Okay, so NamesCon is heating up, and I had a call today with John Berryhill and Jessica McDonald. Now I'm looking at this. Well, I was just on this call this morning. I think I might have called her Jennifer. I can't even remember. Now, I sure hope I haven't. But anyway, so Jessica McDonald, John Berryhill, and myself are going to be doing a panel called UDRP Essentials. You know, how to avoid getting a UDRP and what to do if you happen to get involved in one, receive a complaint. So we were talking today, but it was very nice to meet Jessica. And yeah, John straightened me up on a couple things. You know, for one, I just realized that I was talking about Okie data when I meant to say Telstra today, but I'm not a lawyer and I'm not that smart. I'll lie and tell you I know a bunch of languages and my IQ's real high, but it's really not. It's the opposite. I know part of Pig Latin. My IQ's in double digit. Okay, so anyway, but John cleared up one thing for me, and Jeff, I went ahead and blamed it on you when I said I was going to say he knows we're going to review the Jiggle case today. That was one of his a case that he represented the domain owner. That's our case, Jiggle, and he sent me the complaint, which we normally don't get to see the complaints. And he sent me the complaint. Interesting case, very interesting case. John was successful. I'm already giving you that away, but I responded back to him and I let him know, hey, thanks for sending this to me, and also for clearing me up on, I'm always screaming about you buy a domain name as a domain owner, and I don't. Sometimes I don't make any moves with it. I just leave it there, and I may end up using it in some legal, non-commercial fashion, even. But I haven't done anything with it, and I always think, I don't have to do anything. But so all these years I've been wrong. According, in the UDRP, you really are, as the domain registrant, if you plan on using a domain name that has somebody else's trademark in it, especially if it's their exact trademark, not even additional words, that you want to show some demonstrable preparations on how you plan to use it in a non-infringing way. And in courts, sometimes you don't have to show certain things. In a UDRP, it actually is part of the, I don't know what you call it, the rule, Jeff, or what are the initial guidelines of a UDRP called? Because you like where that demonstrable preparation comes in. Where is that listed in the UDRP rules or policy?
Yeah, so there's the policy document, which is really kind of the higher level stuff. Um, but the policy may actually contain that language. There are the rules, um, but the rules are more procedural than they are um, substantive. So I'd have to quickly look. I should know that off the top of my head, but the demonstrable preparations, I believe, is in the policy as let's see.
You know, when Jeff, when I said I blamed it on you, I said, basically it's like, yeah, Jeff should have straightened my ass up on that because I say things, and you have before, Jeff. You always, clear me up on rules, policy, and stuff, but felt like an idiot,
Yeah,
so
no.
I
So
wanted to.
that's so demonstrable preparations is in the um, yeah, there it is. Um, in the policy. That's in 4C of the policy. It uses it says demonstrable preparations to use the document. Yeah. So that's the kind of thing that's in the policy. That's under the section how you demonstrate your rights as a registrant to the domains. Um, but a lot of the stuff, the rules are really more like you have to agree to mutual jurisdiction. Um, the form of what the complaint needs to include in it, what the response needs to include, communications after something is filed, that's governed by the rules. And then even on top of that, each of the providers have their own supplemental rules on top of that.
Right. And what we're talking about here, folks, is I used to say, or always felt like you can buy a domain name, and if you haven't made any infringing moves or bad moves with it, why should you be, basically you've done nothing wrong, but the UDRP policy states that you need to demonstrate that you're preparing to use it in a non-infringing fashion. Basically, they do want to see those steps or a step. Not that it needs to be, it's clear, it says it doesn't need to be developed out completely, but how are you preparing to use it in a non-infringing way? So that's why sometimes it can be inferred when you have no plans and you say, well, I was going to create a fan site, but yet you've done nothing to create this fan site. No, you have no evidence to show you've done anything to prepare to, a fan site. Then they can infer, a panelist oftentimes do infer that you registered this, in bad faith. You say you had a reasonable intention or a legal, let's say, intention, but you didn't, go in that direction. So it is the nuances with the UDRP. Basically, I'm saying if you get a UDRP, and I've always said this, you want to reach out to a lawyer like Jeff, like John Barry Hill, like Zach Muskovich, somebody who, that's all they do. Jason Schaefer, for example, that's all they do. Especially for, it's 25 years in. Um, Very important because we discussed it earlier about just, responding, and responding is important, but I've seen a lot of friends respond, including myself. I've responded and not been successful when you don't have the lawyers know really, the ins and outs of it. I've only been doing that. I told John, yeah, only 25 years have I known about the UDRP, doing this show for 5 years, and really, would always get frustrated when I hear, I just bought this domain name. You don't even know what I'm going to do with it. I've done nothing with it. And then I bring up Okie Data, and I meant the Telstra case, meaning sometimes there's these domain names that someone owns, and um, Jeff, so that and you and David can chime in on the Telstra case is basically, in a nutshell, when people refer to it, are saying the domain you purchased, really, we can't conceive of any other way for you to use it that doesn't infringe on this trademark owner. Is that the gist of what Telstra, when people refer to it, what they're
Well,
referring
that
to?
that's part of it. The general rule is that you don't have to be using a domain name for it to be considered bad faith. In other words, an inactive domain name can be considered bad faith, use in bad faith, if, number one, that the mark is well known or famous, right? That everyone should know this mark. Um, and number two is well, there's a couple others, but essentially the second main one is what you said, which is that's really inconceivable that this could be used for any other purpose. There used to be another element that nobody really looks at anymore that says that you've cornered the market of the domains, but that seems to have dropped. But it's really important that the name be you know inactive and that it's the mark is well known, and it's inconceivable that it could be used for any legitimate purpose.
David, what comes to your mind when you hear someone refer to the Telstra case, or when you do?
Well, a lot of panelists will misquote the Telstra case and just say, well, I can't think of any legitimate use for this name other than by the trademark owner, so therefore you're infringing. There's no legitimate reason for having it registered, so therefore you committed bad faith. But that's wrong. There are several factors to it. But in 2024, there was a case involving Telstra where it was narrowed. It was a 3-member panel, and the domain name at issue there was tractus.com. And Doug Eisenberg and Neil Brown and Jonathan Agmon were panelists. So yeah, there's multi-factor checklists. I don't have it in front of me right now, but most panelists gloss over it and just make conclusory allegations or decisions based upon their own personal experience, however narrow that might be. So that is, I think, a wrong practice. Um, there are some panelists that are notorious for doing that.
Yeah, we'll for those who want to follow along, we're going to jump right into our outline, and we're going to get through our cases pretty fast too. Try to get done here within an hour, so that'd be 1:15. Been dragging our asses lately. The outline is at dnlshow.com/outline if you want to check it out. First piece of news was just that GoDaddy's going to, I guess, do something with domainnames.com. That was that domain that Frank Schilling bought for $370,000 at one of Monty's auctions at NamesCon, about 17, 16, who knows. But I remember, I saw the clip again, but I was there too. So Frank bought this name for $370,000. It was part of his portfolio. GoDaddy buys his portfolio, which is mostly what NameFind is now. And John made an interesting point too today. He said he had represented Frank when it was Frank's portfolio, about 8 to 10 UDRPs, and then once it got sold to GoDaddy, he assisted a little bit there, but Jerry took over, Mr. Gerald Levine, representing GoDaddy, the NameFind portfolio, and now it seems there's been a lot less disputes that we've seen coming out of NameFind, and it could be because advice Jerry's giving GoDaddy is that some of the cases, it doesn't have a great defense for, and maybe just get rid of the name as opposed to fight something that's not strong. But anyway, thought it was interesting that there's been less cases now that are rising out of the NameFind portfolio, but maybe the most obvious ones were the ones that John had to deal with when Frank owned it. But okay, so domain names. When you go to this website, domainnames.com, you see it just says something groundbreaking is coming, transformative, something innovative, something disruptive. Well, David, you're a domain investor. What do you think GoDaddy's going to do at domainnames.com?
They're going to turn it into another Dan.com. That's for premium names. That's the best guess I have.
Yeah.
What do you think?
I was thinking they were going to just finally change Afternick's name. Then after I looked more closely, I realized there doesn't seem like they're doing that. But that just, Afternick doesn't make sense. Domain name sounds like a marketplace. But you have any thoughts on that, Jeff?
No. they're not going to rebrand anything that's major, that's for sure. But no, it's GoDaddy's asset. They can, if they can't sell it, then they might as well use it.
Yeah, so I'm thinking of this. Monty Khan and um, Steve. Steve's last name. Why do I always forget? Begins Steve. It's your partner, Jeff. Steven.
Oh, so you
Steve.
meet my partner, it's
Oh,
Scott.
Pruitt. Scott Pruitt. See if I just,
I didn't know
I
who you were
just like,
talking about. Yeah,
I don't know
Scott
why,
Scott
but
Pruitt. Yeah.
and of course, Scott's helped me out for 20 years. I mean, especially when he was over at NameJet. But anyway, Monty and Scott. I'm out of it today. Monty and Scott are going to be guests on our second hour of the DNX show, and I'm going to send you a reminder. Maybe around Thursday, but anyway, to pop in. It's going to be 2 p.m. Eastern. We start at 1 p.m. Eastern, but 2 p.m. Eastern. Monty and Scott are going to come in, talk a little bit about the auction at NamesCon, but also other things, what's going on at Dot Hip Hop, some of the other auctions, and just other things Monty's working on, because it's not just those things. But I'll give also a reminder at the end of the show. But that's this Thursday. To get back to our outline, the after this domain names news, there was this article on DNW got to my attention. So check out dnw.com. But this boot company named Freebird filed an ACPA action. So I think it was also a Lanham Act action. I know it's really sort of jointly there, but I don't know if it was just one claim that they made. But anyway, they filed a lawsuit in federal court for the domain name freebird.com. It was an in rem action, right, David? So they were, basically filing this case against the domain name. Explain a little bit about this case and then your thoughts on it, David.
So the trademark, okay, so first of all, Freebird is a title of a song. It's the name used by many different businesses. In fact, when I Google Freebird in Canada, I get different results, nothing to do with anything to do with the complainant. Um, the domain was registered in 1997. Freebird started in 2009, and they didn't get their trademarks until like 2023. So they're coming late to the party. In their complaint, they're claiming prior rights through common law usage since 2009. And according to D0main Gang, he says that there was an ownership change from, according to Domain Tools, that the name changed hands in 2013 and before that in 2005. So, but he thinks both of those registrants from 2005 and 2013 are one and the same. They're both based in Korea. They have the same um, information, so they're probably the same registrant, just different company name. And who knows, it might be the same registrant who got the name in 1997. But anyway, one of the things that's glaring in the complaint is that they keep on saying, oh, this name was re-registered in 2023 and 2024 and 2025. But those are not re-registrations. Those are standard renewals. So that is not something that an officer of the court should be like putting their signature to and filing a complaint. But anyway, at this stage, once the domain owner is served, there might be a different way of serving them, like, for example, advertisement, which is sneaky, because how many Koreans are actually looking at the Washington, which, Jeff, which newspaper do they normally advertise it in?
The Times, which is not even the highest circulation one, the Post would be, but the Times is the lesser viewed one.
Yeah, the Times. Okay. So unless you have a Google alert for domain cases on the Washington Times, you won't ever know about it. So, anyways, it's a sneaky way of trying to hijack the name. Hopefully, the domain owner is alerted to the situation and reacts and files a response. The initial response should be a motion to dismiss, a 12b6 motion. Should hire an attorney in the Eastern District of Virginia, where the court is located, and there are attorneys there that I know that are very good at dismissing these kind of complaints. And this particular
But
one,
one of the problems, David, is that, and I don't like this because it's in my home district, but the Fourth Circuit, with the Prudential case that came down 2 years ago, um, views renewals as re-registrations and says that re-registrations count as essentially new terms. And so, you know, if it wasn't initially registered by, or even if it was initially registered before trademark use came in, but then it was renewed, the Fourth Circuit would say that that was re-registered, and therefore you could register it and re-register it in bad faith. That's one of the differences that the Fourth Circuit, now the 11th Circuit, have from the Ninth Circuit, which is the California courts. Um, and the but on the other side, you have the third, the 11th, and the fourth, which is the Virginia one. So there's a split in the circuits, but more and more of the circuits are going towards re-registrations counting as, or sorry, renewals counting as re-registrations.
I'll have to check that out. I don't remember reading that in the Prudential case, but interesting.
Gee,
Yep.
so that's what makes a lot of sense why Wiley Ryan, that's David Weslow's firm, and I know there's other lawyers that are working on this particular case with him for the complainant, for the plaintiff here. But so, Jeff, that seems like if it's treated equally to a new registration, then it really helps the plaintiff out a lot. And so this new registration, they look at the use of the name. They can say, I mean, I guess last year they didn't target, but this year they did. But this is an ACPA case, so not a UDRP. So do you feel that the plaintiff in here has a strong case for that exact reason to go after this great domain name, freebird.com? I mean, the plaintiff's attorneys must think they do have a shot, but how good is their shot at getting this domain name, even even if it is in the Fourth Circuit?
Well, we haven't looked at the, I haven't looked at the exhibits or anything like that, and you just see their allegations. But yeah, I mean, they realized that they could probably not likely succeed in the UDRP because of the re-registration issue, but they can in the Fourth Circuit, and so that's probably why they went straight to court. Um, and I haven't looked at the evidence and I read the complaint, but yeah, they have a decent shot at it. I think there was on the Freebird, there was the website there. They were actually displaying um, boots. Was that the boots or was that the Galfer one? I'm mixing up, but I believe in that one. I
It
think
was
it's
the boots.
Freebird boots. Yeah. So there were definitely. Um, from what I remember seeing in the complaint, there were certainly references to the registrant marketing boots and other things that compete the um, with the plaintiff in the case.
The DNS is set to parking crew. So it's parking crew serving up those ads, and the registrant would have no idea what ads are being served where at any given moment in time.
So is parking crew part of the registrar? Or are they receiving revenue from it?
Parking crew is not part of the registrar. They do share revenue usually with the registrant, but some registrars actually have a partnership with parking crew, like for example, Pork Bun. So when a name goes into expiration, they start serving up ads that may cause your name to be at risk. And that does not go to the registrant, it goes straight to the registrar.
Okay, but that's upon expiration. But normally it wouldn't go there.
Correct, unless you didn't update your DNS records afterwards, because most people don't even bother to check. They just renew their name and they don't realize, oh, my DNS is still not back to where it was.
Hmm. Well, um, that because in theory the registrant's getting revenue from it, and it's not the registrar just putting up it's on its own. Look, a registrant's responsible for what's on their website at the end of the day. and that's the way the courts will see it. So, yeah, I mean, going to these parking companies does not necessarily do you service, especially if you have a valuable name. Yeah, I don't know how much you're going to make from the traffic revenue these days, but you know, you're subjecting yourself to a big chance of having a UDRP because the parking companies don't care.
There is actually a decision from the Eastern District of Virginia that says that parking ads are a business and legitimate use. This is more than 15 years old. I'd have to dig it up, but I
No,
remember
no, I
seeing.
mean it can be legitimate use, sure, but not if it's advertising the business of and it's infringing on the rights of a trademark owner. I mean, if it just had ads that were related to Freebird, the song, and all the people that make the request to play Freebird at every single bar and club in the United States, that would be something very different than what it has now, which is displaying, or at least according to the plaintiff, displaying Freebird boots and other things that would compete with this company.
The plaintiffs' attorneys, they stop it in time. Like now we see that they have these PPC links that are competing. They re-registered. As we know, they renewed the name right before that, or maybe during that time. It's um, what we're discussing here is can really get involved. That's why we said earlier you need domain name lawyers to handle things like this, and especially make sure you're in the right jurisdiction, because the Fourth Circuit, like Jeff said, on the East Coast where VeriSign is in Virginia, they consider a renewal you're re-registering the name. It's like a new registration date. Way over here in the Ninth Circuit, whether it's Arizona or California, the Ninth Circuit has ruled the original registration date, even if you bought the name in 2020, if that's still got that 1998 registration date, they consider that that's the date you go with, that the non-bad faith registration, or the good faith, if you want to call it that, registration that occurred in 1998 carries forward. But okay, so I don't want to confuse people, but for those who are it's advanced level, and that's probably above my advanced level of understanding the UDRP and the ACPA. I have a question for you, Jeff and David, if you know the answer, and that is, if this defendant in this case was a U.S. citizen and they had the name registered, this was a .com, freebird.com, it was registered at GoDaddy. This plaintiff filed an in rem case against the domain name, like against the property. Could this, if it was a U.S. registrant, basically defendant in this case, could they have said, we come forward, we registered this name at GoDaddy, we would like to move this case to the Ninth Circuit? Would that be a possibility?
I think that happened in a case recently. We'll
Well, it
talk.
tried to happen. It depends on who's got jurisdiction, right? I mean, if you're basing, if it's a GoDaddy case against GoDaddy, then the Ninth Circuit could be appropriate, but not if it was filed by a plaintiff in the Fourth Circuit. You can't just move it um, under the ACPA if there would be jurisdiction in, the say it was originally brought in the Fourth Circuit, and it was a .com name, then there's no reason why the Fourth Circuit wouldn't have jurisdiction because VeriSign's located in the Fourth Circuit. The only thing that might save you is if the plaintiff lost or the plaintiff agreed to jurisdiction in a UDRP, and that jurisdiction was where the registrar is located. But absent that, if it's just a case filed and there was never a UDRP, whoever it's first filed governs.
I got you. So even though that plaintiff in that case is from Colorado, they don't have to mention Colorado, other than they're going after the property that's a .com, that's from a registry, VeriSign, and that's why they did it. So okay, I mean, I mean, it makes sense what you're saying, Jeff. They first filed it there. They don't have to, and that's one of the okay, jurisdictions. Then doesn't need to be switched. All right. Well, we'll see what goes on with this. They filed that, but the next piece of news was something simple, and we'll get through it. Was Identity Digital was hiking the domain prices. That was also a DNW article that came to my attention. DNW.com. Andrew Alleman, go check him out. Identity Digital was raising the prices on a lot of their GTLDs. So some that you might have, like a .chat. I think I have one of those. Probably let it drop. But .vision, .cool, those have went up by 30%. So those have different rates. So whatever 30% is, to give you an idea, though, church went up 45% to $45. Plus went up 31% to $42. They have a lot of extensions there. I believe it was 231 TLDs that they raised the price on all of them. So keep that in mind if you have an extension that's operated by Identity Digital. They're going up anywhere from just 6% to 220%. I guess one of the bigger ones was .lotto, who uses that, but it went up to like $100 to $1,450 a year. So you can imagine that's got to be owned by, very few companies that want to use a .lotto, because that is not a domain investor extension. They're not paying over $1,000 for a name, over $1,000 for a renewal on an extension like .lotto. But keep that in mind. If you have some investments in GTLDs, likely some of them might be Identity Digitals, and your renewal will be higher this time. So check it out. Don't just be on auto renew. You may be unhappy then. This next story was on D0main Gang, and it was really just saying, when you get a UDRP denial, where can you go? And we just talked about it, but going to federal court, the path for trademark owners is to file a lawsuit. Is there there's no appeal mechanism for the UDRP right now. So other than, I guess, in the U.S. filing a federal case, but what do people do in Canada, David? I mean, can you file a federal case in Canada? Is there some, way to, once you're denied in a UDRP, to still appeal the decision in Canada? What are the ways to do that?
So all the cases that Two Cows have lost were appealed in the Superior Court of Ontario, because Two Cows is based in Ontario. Federal court does not have jurisdiction over valuable domain names because that's property. And domain names are considered property in Ontario, according to Two Cows versus Renner. So you don't go to federal court, you go to Superior Court.
And Jeff, you know anything about Europe, or what happens there when you're unhappy with a UDRP decision and you're not a U.S. citizen, you're over in Europe? What recourse do you have?
You're screwed. No, there's, there's, my understanding is the UK doesn't have any legislation that can deal with it. Neither does Australia. So really, most of the cases are brought here in the U.S., especially because most of them involve .com. So even if you're not from here, it's still best if you could try to get it under the ACPA.
Yes.
Well, on that issue, Jeff, when a complainant files a UDRP complaint and they select one jurisdiction, say the registrant's home jurisdiction, and say they happen to be in Australia or Europe, do they change that after they get the registrant's identity and say, oh, we can't even appeal there, it's not a mutual jurisdiction, we'll put it to the registrar location? How does that work?
Well, yeah, they can revise once they get the information about the registrant. They can revise any part of their complaint, or they can choose to submit it the way it was drafted initially. Most of them will choose where the registrar is located, almost always. Well, I shouldn't say that almost always, but yeah, most likely it's where the registrar is located, because those are usually predictable. But yeah, if you pick the registrar and then you find out, no wait, the registrant's in the U.S. Once you get that notice from the UDRP provider, you can amend your complaint.
Welcome to Screw City. Hey, okay, we're going to get to our cases, but I wanted to say one last thing before we do that, and that is go to our outline, dnlshow.com, click on outline at the top, or you can just go to dnlshow.com/outline. And I'm doing this for the next few weeks, and while the nominations are open, you can click, there's a link there. The ICA, you don't have to be a member, but each year they accept nominees for nominations for the Lonnie Borck Memorial Award, and now there's this new Trailblazer Award. The Lonnie Borck Award, I have nominated Jeff Neuman, who is well deserving of this. And if you click on the, it's B6 on our outline, but where you make the nominations, it'll tell you here's the type of nominees that they're looking for and how to place a nomination, how to vote. So I have information there. You only need the person you nominate. You just need their email address. So I've included on our outline Jeff's email address because I'm wanting friends and colleagues of mine to not just support Jeff, support me in my nomination of Jeff. So hoping that happens. But Jeff doesn't say much about this, but the Lonnie Borck Award is really made for someone like Jeff, who has done a lot of work on behalf of domain investors, but really moved our industry forward in many different ways. So that thanks for listening. And for the Trailblazer Award, I nominated Chad Fokening because I think equally with the Trailblazer Award, there's guys that have really been groundbreaking, pioneering in certain things with regards to domain development. And Chad's not just a partner of mine that is into Web3 and was one of the first ones to tokenize names. He founded Domain Holdings, and he really innovated a lot with regards to brokerage services. And now Domain Holdings is a company that's owned exclusively by, just had his name, Mark Daniel. And Mark's wonderful too. But anyway, just a real innovator, Chad is. So now that they're accepting nominations for two different things, the Lonnie Borck Award, I suggest Jeff, and the Trailblazer Award, Chad, and I have links on there. So I just wanted to say that. Now we're getting to our cases. The UDRP case reviews for today. Our first case is the domain Galfer, GALFER.com. So this domain name was registered, I'll tell you, in 2015. It's important in this case because the complainant in this case, Industrious Galfer out of Spain, filed this complaint versus this Korean registrant. Okay, the complainant is a Spanish company that sells brake discs, brake calipers for motorcycles, bikes, and quads and stuff like that. They've been around since 1952. So they've been around a long time, but they sell through stores, through distributors, and online at their own website, Galfer.eu, and they've had that name since 2012. So the domain was registered after they started using Galfer.eu. The disputed domain name resolves to a PPC page with links to the complainant and competitors of the complainant. Okay, so that, well, automatically doesn't look good, and add it to the fact that the respondent did not reply in this case, maybe because it was in English too. But okay, I'm going to stop there. First, I'm going to go, well, Jeff, why don't you jump in, and then we'll have David jump in. But there's some more facts to this case, but give us some of your thoughts on GALFER.com and the case that was filed by this complainant.
You mean the typo of golfer? This is why when I first looked at it, I thought it was golfer. Yeah, I mean, there's not much to report because there was no real response. And when you went to the parking pages, um, or you went to the website, you saw again parking pages that list the Galfer brand, or the products that Galfer offers, like what is it, brake pads, things like that. And so, that's, if you're not going to respond to a UDRP complaint, and there's evidence on there of using the domain for a website that has pay per clicks, and those pay per clicks relate to the business of the complainant, you're not going to have an easy go of it. And they didn't hear.
Yeah, it's got a Sato parking DNS, and I'm seeing that brake related parts. Casson Parks is advertising gaffer rotors. I don't know why, because I've never heard of that company, and it's just like a search mixer. But it's just another reason not to use these automated parking landers. That's a big issue. Um, the domain was registered a long time ago, 2015, and the registrant, well, the registrars are out of Korea, and looks like the registrant is also in Korea. They didn't want to respond, but here's the thing: the complaint was in English. The complainant is from Spain, and they said, "Well, let's put it in English because it's going to cost a lot of money to put it translate into Korean." How do you feel about that, Jeff? That's a big issue. Why doesn't the registrant get access to the complaint in their native language where the registrar is and their country's language?
Um, and I can't remember which registrar they used in this case,
It's
but
Megazone from Korea,
from Korea. And what language is their registration agreement in?
Korean.
They should have gotten the original complaint, a copy of the original complaint in Korean. But then once it gets to the panel stage, if there's nothing filed by the respondent, then the panelist has as it exercised in this case, the discretion to use um, whatever language it wants, essentially. Uh, and so therefore no one requested that the panel use Korean. Even though it looks like this panelist, I think is from Korea and could have done it in Korean.
Yeah, I think the panelists should have demanded to be in Korean, especially since the complaint was filed in English, and it, they're making excuses. And they use the reason that, oh, the ads are in English, so therefore the complaint should be in English. But if the ads are in English, they're not creating the ads; they're automated by Sato.
Whose primary language is English.
Actually,
Um,
German. Sato ads, I think, are generated out of Germany.
yes, but they primarily serve up English ads. Um, but the point anyway is that panelists always look at the content. So if take it out of the pay per click area, but if it were, let's say there was actual stuff up on the website, and if that was in English, then obviously you as a respondent know English if the content up there was English. So that's what most panelists will do.
For the folks listening, what happened in this case, this was a WIPO case. The complainant filed in English. Jeff said he's a Spanish company, filed in English. The center, WIPO, contacted or sent an email out in English and in Korean to both parties saying, hey, this registration agreement, and they wrote this in English, I'm sorry, and Korean. The registration agreement's in Korean, um, and the complainant was the only one that responded back and said, well, I prefer English. And since the respondent didn't reply back to say, no, I prefer Korean because it's in Korean and I'm Korean, that the WIPO didn't even consider. They just basically said, okay, then no, you don't have any, resistance or any refusal of it being in English, so they just went forward with it. But anyway, the panelists mostly, in this case, found that it was more likely than not that the domain registrant registered the name with the complainant in mind, and basically to unfairly profit from their, the likelihood, the confusion there. And we don't, without answering back, we don't know. I doubt if that was the case, that they had them in mind there in Korea, GALFER. I included this case because I'm thinking a lot of domainers, if we saw the domain GALFER, if you could get it for a low price, it's better than a lot of names. You probably pick it up for $50, $100, a few $100. Seems like a pretty good. And Jeff's right. Could be. Some people pronounce the ALF golf, sort of in that manner. So it really is a misspelling of golfer, but it really is just a brandable type name, in my opinion. But anyway, this respondent didn't answer back, and the plaintiff just said, you most likely, I believe it more probable than not that you registered this with the complainant in mind and to make money off of their trademark. And then he further went on to say, the panelist said that, yeah, this domain owner has lost other UDRP decisions. So I'm holding that against the respondent too. Basically, like, yeah, this isn't anything new for them. So we see once again that a history of losing UDRPs can haunt you. Okay. And it might have haunted this person even if he responded. But I guess I could ask.
So Jeff,
go ahead, Dave.
is there a defense that there are many trademark holders for the word golfer, and it's also a surname, but and their trademark holders are in different industries, like one is pharmaceutical and one is in car brakes. I'm looking at the White Pearl Brand Index. There's 109 entries in a variety of classes. So how do you respond to a situation like that? And like you say, well, it's not just this complainant who has rights in it. There are other people who have rights in it too.
Well, then it comes down to a couple things. One is how, and most important is how are you using it as the registrant? And so if you're using it like this registrant as a parking page to point to competitors of complainant or the complainant itself, you could, the fact that there are others just doesn't really matter. Or if you have demonstrable preparations to be using it in connection with something different than what the trademark owner uses, then you would have an argument. But just making that argument that there are, unless you can argue that this term is somehow generic or is descriptive, the fact that there are other owners doesn't necessarily help you, absent showing, you had prepared to use it for something different or you were using it for something different. But absent that, you don't have much of an argument.
Yeah, this domain was used by another business in Barcelona before, nothing to do with brakes, but they dropped it in 2014, it looks like, and then 2015, the current registrant got it. And what did they do with it when they first got it? I think they replicated the old site. And later on, it became this brakes, this Sato parking page. So that's interesting.
If you're a company around the world that's had a trademark for 20, 30 years, especially before, well, for the last 20 years, because this domain was registered 10 years ago. But if you've had like I said, a company that's been around for 20, 30, 40 years, you have an old trademark and you're on your country code, you can, if the .com, and I'll believe it, a lot of them are just for sale, you file a UDRP to try to get the .com. If the person doesn't answer back, your trademark predates their registration, and you can certainly, you certainly have a shot at it. You see so many non-responses. Anyway, this was a transfer. So the domain owner lost galfer.com, had it for 10 years. It's a Korean registrant. He got transferred away from him. This next case, I'm going to say, is it pronounced the Coromandel? Coromandel? Anyway, the THE COROMANDEL.com. That Coromandel is a place, it's a region in New Zealand, just so you know. But this complainant in this case, Destination Hauraki Coromandel Trust out of New Zealand, filed this complaint versus this um, Es- Escavov. It's just my writing. I could read it if I wrote it right. Askar. It's basically an investor out of Kazakhstan. So this complainant founded a long time ago, 1987. It's a charitable trust. It's one of like 30 regional tourism organizations in New Zealand. So they promote this particular region, Coromandel region. What was interesting about this case, from 2000 to 2025, the complainant was on this domain. The complainant spent a lot of time, sending traffic to this domain name, had a bunch of different third party businesses on this name. Basically, they're promoting this region. Go there, travel there, go to these businesses, basically just talking about this area of their country. So they had it for 25 years. They inadvertently, let it expire. And the respondent saw this name at auction, thecoromandel.com, and bought it for 12,500 bucks. That was just May of this year, so not many months back. Well, okay, so the complainant's like, damn, we screwed that up. So they filed this UDRP, and I think they made a fairly good case. One, that this domain was dropped, registered, acquired here, um, the middle of this year, and we've spent a lot of time, a lot of money on this, and we believe we have a, a common law trademark to this and rights to this. So going to you, we'll go to David, and then we'll go to Jeff next on the next case first. But David, this term, the coromandel.com, tell us if the complainant was successful in proving they had trademark rights here.
So the complainant argued that they had trademark rights and that it was protected geographic term in New Zealand. But then there's a white wall overview on this issue saying that when geographic terms are used for their only for their ordinary geographic meaning as a trademark, there is no trademark rights that they get from that. They didn't have it says except where registered as a trademark, so they don't have standing. And that was the issue here. So they said they didn't have standing, even though they had a directory on there with thousands of businesses listed in the Coromandel region. I looked it up on YouTube. It's a beautiful place with nice sandy beaches and rocky cliffs. Um, and then in the interior, it looks like if you're in the movie The Hobbit, with these jungles and vines everywhere. So it's an interesting place. I wish I'd been there before. Um, but yeah, I don't think that this case was a winner in any way, and they didn't help themselves by not having an actual registration. So that killed the case, and the case was dismissed. I don't know what else they could have done, but they had the name before, they forgot to renew it, and they dropped it inadvertently, potentially or likely. But that's what happens when you have different people managing things and you don't have any backup. Can they do anything about this now? Yeah, they can get a better name, get coromandel.com. Somebody in New Zealand actually owns it. His name is Peter, and he's not actually using it. Maybe he's using it for email, but nothing beyond that. So I'm sure that he can be persuaded to recreate the old site and serve the interests of the community for some money. What do you think, Jeff?
Yeah, I mean, this is one of a line of geographic cases where unless you could show you have a trademark, um, establishing common law rights is going to be very difficult. And I was impressed with the analysis done by this panelist, who I haven't seen too many decisions from. Um, and yeah, I mean, the very first thing you have to prove, no matter how the domain is being used, is that you as the complainant have common law rights in the name, or you have rights in the name, usually shown with the trademark registration, and if you have one, it's presumed. But if you do not have a trademark registration, then you have to show it. And it's really difficult to show you have trademark rights in the domain name, or sorry, common law rights in the domain name itself. What I mean is, here the mark was whatever the geographic area. I'll let Todd be the pronunciator of that. Um, but they were claiming that the rights weren't to the geographic area itself, but to the geographic area plus the .com, because they owned the domain for 20 whatever years. But the panelist was absolutely correct and referred to New Zealand law, which also is in line with U.S. and other Western countries' laws, which says that essentially when you're figuring out what the trademark is, you don't look at the .com. You look at unless you have a registration that includes the .com, you ignore the .com, and you can't claim common law rights in a geographic area if what your services are promoting that geographic area, right? They gave the example like Nantucket. If you were a tourist association for Nantucket, you're not going to get common law rights in the term Nantucket, but you may get rights if you're Nantucket Nectars, selling goods and services under that brand. That includes Nantucket, because you're using it in connection with something other than its geographic significance.
Right, very good points there, because this would be similar for those listening. It'd be like if someone owned theamazon.com and they're promoting tourism to the Amazon and they're talking about the Amazon. The person's not going to be able to get trademark rights to say, we own the Amazon for things related to the Amazon. Now, if it was the Amazon and it was a restaurant, and that's different. Now you're in a different class. But this company, this trust, did exactly that. Had the Coromandel, and they were promoting tourism, to this region. But the complainant also said in this case, the respondent can't offer gambling because it's not authorized in New Zealand unless you have these licenses, or it's only by certain folks. And they bring that up. Jane Seeger, who was the panelist, didn't even address number 2 and 3, because she said, you didn't show that you had standing. You can't have a trademark to that in the capacity that you wanted. So I'm not even going to address 2 and 3. Unlike last week when someone sort of, okay, well, I don't know, you're not really proving you have a trademark, but I'm going to go ahead and look and see if this person has legitimate interest. So I like that this panelist didn't look at that, because this panelist, if they did like the person did last week, they may have looked at this gambling and said, yeah, you know what, this is not legitimate in this area or whatever. But anyway, so this was a complaint denied. Jane Seeger said, nope, you didn't even show that you've been successful at the first element, so I'm not going to address elements 2 or 3. Complaint denied. Get lost. This next case, Jiggle. Imagine owning the name JIGGLE.com. Chad Wright owned it out of maybe he's out of Florida. But anyway, Jiggle LLC, I'm certain, is out of Florida, because I did see the complaint that John sent me, and they're out of Boca Raton. But Jiggle, Florida company that offers caffeinated gummies. Okay, so this company had a trademark for Jiggle that just got registered here in 2025 in July, and it was for some kind of caffeinated product to stimulate a person. Okay, so this domain was acquired, or the respondent acquired the disputed domain in May 2015. So though it still has a very old registration date, 1996, the respondent was upfront and said didn't acquire it until 2015. Oh yeah, by the way, in this case where Jiggle LLC filed it against the domain owner Chad Wright, John Berryhill was representing Chad. So, John takes in the complaint that this company's basically just pissed. They think they're going to get this great domain name because it was offered for like $100,000, then like $150,000, then $200,000. You guys might not have you and Jeff, you and David didn't see the full-on complaint that Judd sent me, but the summary is pretty good. It finally got to the point where it showed the complainant was offering it for $350,000, but I'm sorry, the respondent was offering for $350,000, but the complainant was upset because the respondent kept raising the price and kept saying, "Listen, 100,000 is way beyond the $10 to $20 a year registration cost. So 350,000 certainly is." And this respondent is engaged in, quote, speculative domain flipping, which the complainant said establishes a pattern of abuse. John did a great job of, undoing that, saying it doesn't show a pattern of abuse. It shows this domain owner has owned several other names, sold them for very high dollar amounts, and usually he waits until he can extract the highest dollar amount from his domain names. So not uncommon for him to have names that many different folks can use, and he offers them for super high prices. Um, there's some other things in the summary I'll let you guys get to. Jeff, what did you see in this case that interested you? Anything that was sort of straightforward?
Yeah, I mean, it's very straightforward, right? It's that they only had trademark rights since 2000, since this year, 2025, the complainant, and the registrant got it, what, 10 years before that in 2015? And that's pretty much case closed, right? Um, After that, there can't be bad faith if the company didn't exist or have any rights prior to when the domain was registered. And that the reverse domain name hijacking usually falls when there's no possible way to succeed in the case, as there was here. So yeah, I mean, it is very straightforward. It was an easy case, one that should never have been brought. And I think the other thing that the opinion mentioned, which I liked, was, look, you knew, complainant, when you picked the name, even prior to this particular um, respondent owning the name. It was owned since what, 1999 or something like that. So you knew when you picked this name that someone had the .com version of it, and yet you still went forward and got it. And so that's on you. That's not anyone else's fault but yours. And so I kind of like that little jab in the decision.
Yeah, they're on
Yeah. And
jiggle.cafe. Go
it's
ahead, David.
interesting that they mentioned there was PPC ads on the website in 2018. Currently, it has a GoDaddy lander make offer contact form. So you just have to enter your information to get a price through the GoDaddy broker. And yeah, the timing is just kills the UDRP complaint because there's no way to say that you have rights prior to the registration date or acquisition date in this case. So there's no bad faith.
Yeah, and they did rule reverse domain name hijacking because of that. Said you should have known that they didn't register this name in bad faith. It was way before your mark. But I like that the panelists did say, you know, because a lot of people think this selling at a cost way above your costs is not enough to show bad faith. The disputed domain must have been purchased to sell to the complainant or to complainant's competitors. So we hear that all the time. A lot of us would buy a name, especially if you spent, 1,000 to 10,000 or more in an aftermarket auction. You might offer it for 150,000, 250,000. There's nothing wrong with that. It can contribute to a finding of bad faith if you've bought it intentions to selling to the complainant or its competitors and then listing at that high price. But anyway, the panelists said just by listing at a high price doesn't, mean bad faith. Doesn't, and John helped them get to that statement by presenting his case. That panelist was Kimberly Chen Nobles. But anyway, so that was a complaint denied plus RDNH. That's going to do it for us today. If anybody has a question for the lawyers, now's the time. You can raise your hand. I'll give you a couple seconds to raise your hand if you have a question you want to ask the lawyers. We get out of class early today. Once again, I wanted to say on Thursday at 10 a.m. Pacific, 1 p.m. Eastern, Josh and I are going to talk about how to find some undervalued names in the aftermarket, because it's basically a domain investing show that we do. And we're going to, we have a special guest too, Scott Pruitt and Monty Khan of Right of the Dot. They're going to talk about the big names con auction, how you can submit your names there still. It's winding down to less than a month away, how you can submit your names, but also give us a highlight of what names are going to be auctioned off. And he's also doing one in Dubai at Dubai Days. So Monty will let us know how you can bid on names that are going to be at Dubai Days. Before I get to Brad, I'm glad Bradley joined us on stage. I want to ask you, Jeff, when are you taking off for Dublin?
I think the 24th. Yeah, what is that, Thursday? I think that's one of them. Yeah.
Right. So we got a couple more weeks, and then I guess maybe you'll be gone and then come back. But yeah, it's a lot of folks. I don't know, reaching out to me. Are you gonna be? No, Jeff. What's Jeff's schedule? How would I know Jeff's schedule? And like you only got a couple nights there. You got people want to have dinner with you. Now you're at the point where I don't know if they want to buy you a nice dinner, some Dublin steakhouse. But anyway, I know you're gonna have a good time. It's ICANN 84 for those wondering. That's coming up in Dublin. But good. So don't have to worry about it next week. Jeff's still around and even the following. But thanks. Bradley, what question or comment did you have?
Hi. Thank you, Todd. Thank you, Jeff and David. About the Freebird, what was the name of the company that was seeking to get Freebird.com?
Freebird Boot Company out of
Okay.
Cucamonga. No, I don't know, out of somewhere. Yeah,
And
Freebird
then
Boot Company.
the questions I had was when you were talking about in the district whether every re-registration is considered a new registration when you renew it. How does that apply to owning the domain name prior to someone getting the trademark, like in the UDRP case?
Well, so that rule only is in litigation in court in certain circuits in the U.S. So that rule doesn't apply in UDRP cases. Renewal of domains does not count against any domain name owner in a UDRP.
But
However, it does in the Fourth Circuit if there's a case brought um, for the Anti-Cyber Squatting Consumer Protection Act.
so even if it's the same person that's owned it from the original date, they count the new or renewal date as when they was acquired?
That's what they do in the Fourth Circuit. So that's what Virginia, North Carolina, Maryland, and also in the 11th Circuit, which is Florida, Georgia. I'm forgetting what else is in that third or the 11th Circuit. And then in the Ninth Circuit, so the Arizona, California, um, they do not count renewals as re-registration. So it's the other way.
So, in other words, in those cases, it doesn't matter when you owned the name, correct? Which
So in the
is counterintuitive to the whole protection aspect of having the insight to own a name prior to someone else taking advantage of it.
Yeah, and then it just basically in those circuits is it really looks at your use of it. So if you're using it in bad faith, um, regardless of when you registered it, um, you're in trouble in those couple of circuits.
Okay. And in that regard, it's better to not have a PPC page, right? Because you have no control over that. in bad faith aspect of it.
Well, I would say in a UDRP case, it's never good to have a pay-per-click site. Um, unless you could tell me that the money you're going to generate is so much more than the value of the name itself. I never think a pay-per-click link page is a good idea.
Brad, that's why
Okay.
in that case, the Freebird case, they filed a lawsuit because if they would have filed a UDRP, that predated domain registration would have meant something. So it doesn't mean in court you have to use other defenses. Jeff's just saying you're not going to be using the registration date defense because they're going to look at your most recent renewal. Now, domain investors don't renew names for 10 years, but you can certainly imagine it'd be helpful if you owned a name, you renewed it a long time ago, so you don't have these constant renewals annually that basically discard all that time that you've accrued with the registration because each renewal is new. So basically, in court, in the Fourth Circuit and 11th Circuit, like you said, you have to come up with other defenses to say you're not, why you're not, squatting if it's ACPA, or why you're not
But
infringing on their trademark if it's a Lanham
but
Act
but
case.
didn't that case turn on the fact that on that landing page was the PPC that had the boots on there? And if this guy just had it on a landing page for sale without any PPC, he would have been able to keep it? Is that the case?
It hasn't been ruled yet. I mean, but yeah, but what I think, and believe me, I don't know, we could probably, you know, ask around and find out, but they probably filed this case because they saw, look, perfect, great, fantastic. There's the last renewal, so we can use this date. It was just renewed, like it's brand new registration. That's what they consider in that particular circuit, in that district. So that plus with the PPC page that shows, look, they have boot links there, some to us or to competitors. That's exactly what we needed to show the bad faith. The registration date, the most recent one is certainly after their trademark because we're using a recent registration date. And that's exactly why they probably filed the case in court, because of a few of those facts, that they could use that late registration date, they could show those PPC links, and they obviously filed a case instead of doing a UDRP, because if they would have filed a UDRP complaint, they knew it's probably just going to get a complaint denied. But in court, we'll still see what happens. We haven't seen, I think, the response. We've only seen the complaint. So hopefully this domain owner has, solid response to this case. We'll follow it, if they don't lose anything.
That's very. Shows kind of like a loophole in regards to when you have a smart legal team to go around a UDRP and go directly to court,
You
and
can
that's a
imagine
smart move for
what a great
them.
name, Freebird. Like I said, tons of companies use it, and of course we all know
Yeah.
the Leonard Skinner song "Freebird." You can't be a
Thank you
domain
very
owner and not know
much.
it. Yeah. No, thanks, Brad, for coming up here and really, bringing that up again. Everyone, once again, thanks for being here. Enjoy your day wherever you're at. We're going to end it for today, but we will see you on Thursday. So please be sure to join us on the DNX show on Thursday. Have a great rest of your day.